Divorce is an emotionally difficult situation that most people wish to avoid. However, divorce and separation are still sometimes inevitable. For those who are just settling down in the country and are in the process of obtaining their permanent resident status, divorce can be particularly problematic. So, if you divorce your spouse before your green card interview, how will that affect your status? In this guide, we'll discuss the process of continuing with your green card acquisition after divorce. If you have filed a petition for permanent resident status, then your application process has begun. However, if you become divorced before the approval of your green card, the situation will be decided based on your entry status. This depends on whether you're the primary beneficiary or the derivative beneficiary of your entry visa. If you're the primary beneficiary of an employment based visa, for instance, you may continue with the green card application process. But as a derivative beneficiary, since you're no longer the spouse of the primary beneficiary of the visa, you can't continue the process. USCIS will want to ensure your marriage is bona fide, especially if it's less than 2 years old. So when you apply for a marriage-based green card, you're going to be issued a conditional permanent resident status renewable after 2 years. Dissolving the marriage in less than 2 years of your permanent resident status will likely be a red flag to USCIS officials. Therefore, this situation will require extra effort to prove that the marriage was legitimate from the start. To do this, you'll need to file and submit a waiver for the I-751 joint petition, meaning you want to process the removal of conditions on your green card without your ex-spouse. Some of the evidence to present while filing your waiver includes showing irreconcilable differences between you and your ex-spouse. You may show proof of adultery, criminal behavior, or battering by your spouse. You may also present evidence showing your attempts to reconcile, for example, records of sessions you've had with a marriage counselor. Keep in mind, however, that your claims, regardless of how terrible, will still be put under intense scrutiny by the USCIS. It's advisable that you consult your immigration lawyer before filing that petition. While divorce and separation before the green card interview attract increased scrutiny, there are some differences in dealing with these two closely related cases. Divorce is when a court of law formally dissolves a marriage, while a separation means married spouses are living apart, usually because of conflict in the marriage. Couples who are separated may also choose to formalize it by entering into an agreement authorized by the court of law, indicating their decision to put the marriage on hold and live apart. While separation may be part of the divorce process in some regions, the marriage is still legally valid until it is formally dissolved under the law. Divorce laws in different U.S. states also vary, so you will need to know what the law says in your state. Because separation does not end the marriage, the couple is still considered married. This also means that the marriage-based green card application is still intact. In this case, you will be allowed to jointly file an I-751 despite the separation. However, you have to do this within 90 days before the expiration date of the conditional residence. You should also include documents that prove that you are still married. The exception to this is if the legal separation was done in a state where the couple has been considered divorced because they've been separated for over a given period of time. If this is the case, your green card interview may be treated like a divorce case. Even though the separated couples often remain legally married, getting a green card based on the union is not as simple as you may wish. Here are some of the implications of being separated from a U.S. citizen or permanent resident spouse with whom you applied for a green card. Some state laws may classify you as separated. Sometimes, the U.S. citizen or permanent resident spouse may refuse to fill the I-751 form after the separation. If this happens, you can file the waiver of the joint filing requirement and file for permanent residence on your own. In cases of non-cooperative spouses like this, you may choose to wait till the divorce is complete before filing the waiver. Because it's such a sensitive situation, you need to be mentally ready for the interview. The following are tips on how to prepare for the USCIS interview. Be sure you've gathered all the documents you need to support your claims. If you think you need more time to prepare, you may request a postponement of your interview date from the USCIS. Be honest with your claims. Don't try to deceive USCIS officials. Be as factual and truthful as possible. It'll really help your situation. Prepare evidence showing you had a normal relationship before the divorce. You may need to present the certificate of your marriage to show that you've been married for a particular period of time. If there are documents showing properties you and your former spouse own together, you may show evidence of this. Also, if you have a joint bank account, a mortgage payment made in the family name, or other related documents, you may present them to prove your case further. In addition, if you have children together, showing pictures and additional proof will also help convince the USCIS officer. If you've been issued an unconditional residence status before you divorce your spouse, the divorce will not in any way affect your residency in the US. The only area you may be affected is if you wish to obtain citizenship. Ordinarily, if you're married to a US citizen, it takes just 3 years to be eligible for citizenship after the issuance of your marriage-based green card. However, if you're divorced from your citizen spouse, you will have to wait 5 years before you can be eligible for US citizenship. If your waiver application is denied by the USCIS, you will receive a letter detailing why the denial took place and will likely lead to removal proceedings. However, the removal proceedings will first be reviewed by an immigration judge who will decide if you should be removed. If the immigration judge decides to remove you, you may appeal the decision of the judge within 30 days after the verdict. The best thing you can do in a situation like this is to talk with your immigration attorney. We know divorce is difficult, and adding the immigration factor doesn't make it any better. For more resources, visit our website.